All right. Welcome, everybody, to our California call. Thank you so much for joining us. We're excited to have you all here. Um, Today, we've got Avis on with us. So, say hi to Avis, everybody. We've got Hank Yasik with us. We've also got Chuck Michele, who's going to get us started and tell us all of the wonderful things that are happening that specifically impact California. So I'll kick it over to you.
Okay. Well, so Matt is not here today to talk about whatever shenanigans the Cal DOJ is up to lately. You guys all know how to ask questions through the FFLG website, and Matt answers those fairly promptly, and they're all posted. Uh, so I'm not up to speed on the latest. I know in the lawsuits, DOJ is pulling some awfully big crap, as usual, hiding the ball and doing stuff behind the scenes. They're having uh, calls. They don't put it in email other than to schedule a call with all the major gun control groups in the country, regular teleconferences with them to plot their next move uh, to basically screw gun owners and FFLs. Uh, and also on the legislative front, which Matt is pretty much the guy who monitors. I'm not. I just got a report from Rick Travis, the CRPA lobbyist, and you guys may want to make sure that you subscribe to the CRPA bulletin so that you get those legislative reports. They're posted on the CRPA's website. You can circulate those to your customers if you want to, and use them in any way you want to, just as long as we've set them up as a branded CRPA product, so that and then given permission for people to use it as long as they don't take the brand off. But Rick does those every couple of months. I think we've killed, or at least neutered, most of the anti-gun bills that were pending this session in Sacramento. But that doesn't get rid of the ones that are still there, like the cameras recording requirement, which we still have a lawsuit going against. And now the excise tax is obviously kicking in on July 1st. And NSSF wants to challenge that, but it's not a clear path to victory. It's not quite the poll tax that we had hoped it was. There's potential issues with standing, because you have to pay the tax before you can challenge the tax, and we may be limited to state court. So it's not the typical two-way lawsuit that we could file in federal court and hopefully get a good federal judge on. But we may have no choice. But I want everybody to know that CRPA, GOA, NSSF, SAF, we're all looking for ways to challenge that. And I think challenging it is inevitable, but it's not Bruin. It's not the Bruin standard that really applies there when you talk about a tax. We're having a meeting on this tomorrow to get all the lawyers and the brain trust in the room and try and come up with a viable strategy for challenging that. It may be an argument that the excise tax plus the sales tax plus all the other fees combined becomes an oppressive tax on a constitutional right. I think we have a better shot lumping them together. But again, this is something we're still working through. There's been a lot of research done, and so we can anticipate what the DOJ's position on that is going to be, and we just have to be ready to knock it down. So in the meantime, starting July 1st, that tax is something you got to collect. We have a number of other lawsuits going on, but the big Second Amendment picture is there was the Illinois cases challenging the semi-auto and magazine capacity law in Illinois that have all requested cert, that requested the Supreme Court to grant cert and hear those cases. Remember, they don't have to. 4 votes from 4 justices means they take the case, but it takes 5 to win. We should have 5 and probably 6 with the current composition of the court, but there are some of those are they're not final judgments yet. It's an interlocutory appeal from a denial of a preliminary, or the Seventh Circuit overturning a preliminary injunction motion. So it's arguably a little early in the process. We have a trial going in front of the district court judge, Judge McGlynn, in September, and I think we're going to win. He basically gave us a blueprint. He's the one who initially granted a preliminary injunction against the PICA law. By the way, this is all relevant to you guys because Miller and Rupp are both pending in the Ninth Circuit. Those are both challenges. Rupp is the CRPA case, Miller's the FPC case, SAF-FPC case, challenging the so-called Assault Weapon Control Act in California. And Duncan is the magazine challenge. Duncan is a CRPA case. Duncan is back in front of an en banc panel. Let me go back to the Supreme Court and finish that thread before I dig down into Ninth Circuit. So in Supreme Court, you've got the Rahimi case pending. They're at the end of their term. So they only have a few, and their decisions are handed down on Thursdays. So today, they did not issue an opinion in Rahimi. Excuse me, last Thursday, they did not issue an opinion in Rahimi. So on Thursdays, they hand down their decisions. On Mondays, they say what they're going to do with cert requests. So today, they issued a series of orders on all the cases that were pending, and the Illinois case and the Ontonic case out of New York State, where they're trying to play games with what's a sensitive place so they can make your CCW useless. Those were all in conference with the judges on justices last Thursday, and they were not on the list today. So they did not grant, they did not deny, they took no action. That could mean probably one of two things. One is they're going to issue a ruling in Rahimi and then GVR those cases and tell the lower courts, reconsider your rulings in light of what we just said in Rahimi, because even though Rahimi involves a guy who can't own a gun because he has a restraining order against him, if the court clarifies the methodology that the lower courts are getting so wrong, some of the lower courts are getting so wrong that Bruin lays out, the Supreme Court could really slap some of those courts down and say, you're doing it wrong, do it again this way. And that would inure to our benefit, because the Bruin methodology is very much in our favor. The text of the Second Amendment is very inclusive. Any conduct that involves keeping or bearing arms, including related ancillary conduct like buying ammunition and taking your gun to a gunsmith, buying a gun, selling a gun, repairing a gun, training with a gun, all that stuff is covered by the text of the Second Amendment. And they're trying to limit that, trying to say, for example, that magazines are not arms, so they're not covered by the Second Amendment at all. And then if it is covered by the Second Amendment, then you go to the second test, which is whether there's a historical tradition that's analogous to the modern law that shows that the founding fathers in 1791 would have tolerated the kind of law that the state is trying to justify today. There are no historical laws banning classes of people or classes of firearms from being possessed. So it's the state becomes the state's burden of proof. So once it shifts, it's hard for them to find a relevant historical law. The games that the courts are playing on that step is they are using anything. An old Bowie knife law can justify a modern assault weapon law. They're stretching. And so again, if the Rahimi court straightens that out and says, no, here's how you determine whether or not it's an actual sufficient historical analog law that shows a historical tradition of regulating in the way that they're regulating today, then the law it could be held to be constitutional. But if the Supreme Court narrows that so that they don't take all these one-off stretch analogs, then that would be good for us too. So the point is, if Rahimi goes that far, they might say, okay, now we just clarified things in Rahimi. All those other cases, the 3 Illinois cases and the New York case that are pending cert, we're going to vacate the lower court ruling, remand them, all those cases back down to the lower court with instructions to reevaluate the case in light of what we just said in Rahimi. That would be the good news. Bad news would be they just deny cert, and Rahimi is enough for them for one legislative session. And then all those lower court cases have to keep percolating through the system, which brings us now back to the Ninth Circuit. In the Ninth Circuit, we have Rody CRPA cases, Rody challenging the ammo background checks. We have Duncan challenging the magazine capacity limitation. We have Rupp and Miller challenging semi-autos. We have Boland challenging the roster. We have a couple challenging gun show bans. I can't even remember them all. There's a lot of 2A cases pending in the Ninth Circuit, and we've won most of those at the district court level, at the trial court level. Now, some have gone up to a 3-judge panel. For example, Duarte, the felon in possession, the 3-judge panel just struck down that law, said you can't make it unconstitutional for a guy with a non-violent felony to possess firearms. The state has already asked the court to take that case en banc. I suspect what's going to happen is it's going to be stayed until the Duncan case is decided en banc. And that's still under submission. And I don't think we're going to hear from the Duncan en banc panel, until we hear from the Supreme Court on Rahimi. That could be this week or next week. It's coming soon because their session's up at the end of June. So that's kind of where we're at. The stakes are pretty high, but the Supreme Court is stacked in our favor right now. The anti-gun lobby is doing everything that they can to slow things down so that they can hopefully get Biden in office, and he can appoint he can reconfigure the Supreme Court with more liberal judges. It's unfortunate that this is what it all comes down to. I mean, the judge you get determines whether you win or not, basically. So hopefully Supreme Court will set at least some things straight in Rahimi, and we can use that in Duncan. And then once we turn Duncan around, then all the other cases follow behind Duncan, because the standard of review, the methodology should be set out in Duncan. And all the courts that have been upholding gun control laws are applying the methodology wrong. All the courts that have struck down gun control laws are applying the methodology correctly. So watch Thursday for a ruling in Rahimi. Watch next Monday for court action on the cases that are pending cert. And we'll send something out when we see what they do. You guys also, I don't know if you've heard of Mark Smith's 4 Boxes Diner. That's actually a very good YouTube channel to stay up to speed on what's going on in the courts nationally. And again, this all has significance in California. If we win in California, any place that we win becomes a national precedent that can be applied in California, and any win that we get in California becomes a national precedent that can be applied in other states. So it's a national battle, and it's pretty much scorched earth. I think I've said before that the money that's being put into our opponents from Bloomberg and Everytown Law is millions of dollars, not hundreds of millions. Bloomberg pledged 800 million several years ago. So we're up against a well-financed opposition group, and they're very slick and they're very sophisticated. That's part of the Democratic platform. And they want to, trump us. So we just have to keep fighting back with what we can. I'd encourage everybody to become a business affiliate of the CRPA, to put my CRPA hat on for a second, and maybe pass along some of the things that CRPA distributes about these lawsuits. Take advantage of getting up to speed on what's going on in Sacramento through the CRPA's legislative report. And, CRPA has a roundup program and a recruiter program where you can offer CRPA memberships as part of your product line. NRA, I don't know what they're doing. I don't think they know what they're doing. They're obviously in a big state of flux. They're certainly not very active in California at this time. They try to be, or they try to look like they're active, but their legislative advocate has been told she's not welcome in most of the legislative offices. So she can't even get in to talk. So you've got Rick Travis from CRPA, Sam Paredes from Gun Owners of California. They're the ones who are working the legislature. That doesn't just mean going to a committee hearing and talking for 3 minutes. They got to work those people in the hallways. That's where the votes get changed. And they're doing that. That's why we've had some great successes this year. What else? I'm happy to answer questions. I'm sure there's something I'm forgetting to mention. Okay.
No questions?
Nope, doesn't look like it.
So watch Thursday and watch Monday.
All right. Well, we really appreciate it. Thank you so much for being here to give us information. And I'm going to ask just one more time, guys, any questions?
Well,
I know we get.
One other thing I'd mention, Josh isn't on today's call either. Josh is our labor lawyer, and one of the kind of side benefits that you guys get as FFLGuard members is updates on employment law in California, which is almost as bad as gun laws in terms of its political slant. Josh will be on the next call, and he's still available to answer those kind of questions through the FFLGuard website. But I don't know if there are any big employment law changes going on right now. Actually, there's a ballot initiative. There's a ballot initiative to repeal the law that makes everybody an employee and you can't be an independent contractor. So there's some action on the ballot that would change and to repeal PAGA, Private Attorney General Act. Basically, plaintiffs' lawyers have become mercenary agents of the state who can recover their attorney's fees if they find some hypercritical little violation of some employment law, like you didn't give them you only gave them 10 minutes instead of 15 for a break or something like that. These hyper-technical violations can become very expensive. There's also the ADA crap they're pulling. Prop 65, we're dealing with that, with warnings on ammunition boxes or in your stores. So if you guys have questions, I'm not the expert on that. Josh or is. So if you have questions on that, submit it through the website. How do we handle donated raffle firearms? This is something that Matt can answer for you. We had a question about this just the other day. And it's factually specific. So you got to kind of, you should get a free consultation with Matt. He can talk to you about what the circumstances are, what kind of guns you got. Okay. I don't know these answers on the 11% tax.
On the 4473, you cannot shred it and have them start over. Per the new final rule, if once anything is inputted into Section B, you must retain the 4473. So to that end, whether you have them start over on a new form is your choice, right? But you would still have to retain the other form, and it would be filed separately from the forms that a transfer did occur.
Yeah, I apologize for not being up to speed on this. I've been wrestling with the Second Amendment cases and haven't had a chance to really focus as much as Matt and Josh have on the excise tax and some of these other specific doing business type of questions.
As far as internet transfers and guns we sell online that are shipped to other California dealers, my understanding is that they would still be subject to the tax, but we'll definitely get a clarification for you on that. But my understanding is they're all still subject.
Yeah, but I think the tax gets assessed by the ultimate retailer. So if you're just
right,
like if you're the FFL transferring to another FFL, you're not selling the gun, or you are, but it's not being sold at retail. The guy at the end who buys it, the retail customer is the one who pays it. That's my understanding, but let's make sure we clarify that one too.
Yeah, so we'll get a response to you on that, but to say that it is well thought through for an operational standpoint would not be accurate. It's not meant to be easy to execute or understand.
Yeah, close enough for government work. That's what the legislature doesn't care if there's screw ups. They throw it to the DOJ and then the DOJ screws it up worse.
Fair enough. Any other questions? All right. Well, we really appreciate it, everyone's time so much. And again, you know how to submit on the portal. If anything comes up, you need anything, please reach out.
All
Talk
right,
to everybody later.
Thanks, everybody.
Thanks.